Hey guys, tonight I need to tell you about 7 years. Not 7 days, not 7 months, 7 years. That is how long 2 men sat inside Massachusetts prisons, waiting to learn whether the state was going to kill them for a robbery they may not have committed. 7 years of appeals. 7 years of clemency petitions. 7 years of a world watching a courtroom outside Boston and asking the same question, over and over, in a dozen languages. Did Nicola Sacco and Bartolomeo Vanzetti do it? On the night of August 23, 1927, just after midnight, the state of Massachusetts sent an electrical current through both of their bodies, one after the other, in a wooden chair inside Charlestown State Prison. 50 years later, almost to the day, the governor of that same state stood up in public and said something that a great many people heard as an apology. He did not say the word innocent. He was careful, almost surgical, about never saying it. What he said was that the trial had not been fair. I need you to hold on to 3 things tonight. Plant them somewhere in your mind and keep them there, because we are coming back for every one of them. First, a cap. It was found in the street beside 2 dying men, and a police chief tore it open with his own hands before anyone else was allowed near it. Second, a bullet. Out of 4 bullets pulled from a dead man's body, investigators said exactly one of them matched a pistol that belonged to one of the 2 defendants. That pistol was one of roughly 300,000 identical pistols in circulation in the United States at the time. Third, a note. 5 years after the verdict was already final, a convicted killer sitting in a cell down the corridor from one of the condemned men wrote a short confession to a crime that was not his to confess to. A cap, a bullet, a note. Hold on to them. This is not a video about whether Sacco and Vanzetti were anarchists. They were. They said so themselves, under oath, in open court, more than once. This is not a video about whether they lied to the police on the night they were arrested. They did lie, and before this is over, we are going to tell you exactly what they were lying about and why. This is a video about something underneath both of those facts. It is about what happens when a legal system decides who a man is before it ever finishes asking what he did. And it is about whether a state that spent 7 years insisting its process had been fair could, half a century later, only bring itself to admit that it had not been. We cannot start at the electric chair. We have to start 7 years earlier than that, on an ordinary Thursday afternoon in April, in a small Massachusetts factory town, with 2 men carrying somebody else's payroll down a public street in broad daylight. If this is the kind of case you come here for, the kind where the record argues with itself and nobody gets to look away from the argument, then subscribe. So the next time we sit down with a file like this one, you are already here. Now, let's go back to 1908. Nicola Sacco was born in the spring of 1891 in Torremaggiore, a farming town in southern Italy, the son of a man who owned a small vineyard and an olive orchard. He crossed the Atlantic in the spring of 1908, 17 years old, following an older brother who had made the trip before him. He would spend most of the next 12 years doing skilled factory work, edge trimming on machines that shaped leather into shoes, first in one Massachusetts shoe town and then another, eventually settling into a steady, well-paying job at a factory in Stoughton. He married a woman named Rosina. By the spring of 1920, they had a young son named Dante, and Rosina was expecting their second child. Bartolomeo Vanzetti was born 3 years before Sacco, in June of 1888, in Villa Falletto, a town in the north of Italy, the son of a small landowner who had wanted him to study accounting. Vanzetti crossed the Atlantic 1 month after Sacco did, in the summer of 1908, and for the first years found nothing like Sacco's stability. He worked as a dishwasher, a laborer, a factory hand in a string of towns across New York, Connecticut, and Massachusetts, and by his own account, nearly starved more than once. Eventually, he settled in Plymouth and became, in his words, a fish peddler, pushing a cart of fish through the streets of a town that had been founded 3 centuries earlier by people who had also crossed an ocean looking for a place to be left alone. Sacco's 12 years in America had a shape to them. Steady work, a rising wage, a house, a wife, a son on the way to being joined by a second child. Vanzetti's 12 years had almost no shape at all. He moved constantly, chasing whatever work existed, and by his own later account, there were stretches when he genuinely did not know where his next meal was coming from. What he did instead, in the years when there was no work to be found, was read. He was largely self-taught past his childhood schooling, and the letters he wrote later in life, dense with references to philosophy and history, read like the letters of a man who had spent his hungriest years in libraries rather than taverns. 2 Italian immigrants, then, who had lived almost opposite versions of the same journey, one finding a foothold in his new country, and one finding almost nothing but his own convictions to hold on to. It is worth remembering that contrast later, because the state was about to treat them as a single, interchangeable unit. The 2 men did not know each other for nearly a decade after they arrived in the same country. They met for the first time in 1917 at a strike, drawn to each other the way people are sometimes drawn to each other in a crowd of people who are angry about the same thing. Both men had, by then, become followers of an Italian anarchist named Luigi Galliani, who published a newspaper called Cronaca Sovversiva out of a small office in Massachusetts, and who did not believe in gradual reform. Galliani believed capitalism itself was the crime, that the state existed to protect that crime, and that violence against the state was not a last resort but a legitimate answer. His newspaper, at various points, printed instructions for building bombs. Sacco and Vanzetti read it. They believed a great deal of what was in it. Whether they believed all of it is one of the questions this story is never going to fully answer for you, and I want to say that plainly before we go any further, rather than pretend otherwise later. I want to take a moment here and tell you plainly what that word, anarchist, actually meant to the 2 men at the center of this story, because the trial you are about to watch unfold spent a great deal of energy making sure the jury never had to find out. At its root, the anarchism Sacco and Vanzetti practiced was not a philosophy of chaos for its own sake, whatever the newspapers of the era preferred to call it. It held that private ownership of land and factories was itself a form of violence, that government existed mainly to protect that ownership by force, and that ordinary people were capable of organizing their own communities, their own labor, and their own justice without a landlord or a police force standing over them. Some anarchists of that era, Galliani, prominent among them, believed that violence against the state was a legitimate response to the violence they believed the state committed every day simply by existing. Other anarchists, and there is real disagreement among historians about exactly where Sacco and Vanzetti individually fell on this spectrum, believed almost entirely in organizing, in strikes, in mutual aid, and rejected bombings as a tactic that mostly succeeded in getting more of their own people killed or deported. What is documented in both men's own later writing, is a genuine, lifelong conviction that the economic system around them was fundamentally unjust, and a willingness to say so publicly, under their own names, at real personal risk. Whatever else this story turns out to be about, it is not about two men who stumbled into radical politics by accident. Here is something you need to understand about the world Sacco and Vanzetti were living in by 1919, because nothing that happens to them afterward makes sense without it. The First World War had just ended. The Russian Revolution was 2 years old, and the United States government was watching it the way you watch a fire in a neighboring building, uncertain whether it is going to stay next door. In the spring and summer of 1919, a wave of parcel bombs moved through the American mail system, targeting judges, senators, and industrialists. On the 2nd of June that year, a bomb exploded outside the Washington home of the United States Attorney General, a man named A. Mitchell Palmer, close enough to blow out his own front windows. The man carrying the bomb was killed in the blast. Fragments of anarchist literature were found scattered across the street. There is one more piece of law you need to understand before any of this makes sense, and it has nothing to do with anarchism at all. Neither Sacco nor Vanzetti had ever become an American citizen. Under the immigration law of the period, that made both of them what the government of the time called resident aliens, a legal status that came with none of the protections citizenship carried and nearly all of the exposure. A citizen suspected of radical politics could be watched, harassed, even prosecuted. A resident alien suspected of the same politics could simply be put on a ship and sent back to a country he had not lived in for a decade, without a jury, without an appeal, on the word of an immigration officer alone. That threat sat over every Italian anarchist in Massachusetts in 1920, Sacco and Vanzetti included, as a plain fact of daily life, not a paranoid fantasy. When we get to the reasons these two men lied to police on the night of their arrest, I want you to remember that the fear driving those lies had two separate heads. One was the fear of being connected to a robbery. The other, older, better documented fear was simply the fear of being an alien with the wrong newspaper subscription, in a country that had just proven, with Andrea Salsedo's body on the pavement, exactly what it was willing to do about that. Palmer's response became one of the largest coordinated roundups of civilians in American history. He built a new division inside the Department of Justice specifically to track radicals, and put a 24-year-old lawyer named J. Edgar Hoover in charge of it. Hoover's division compiled files on more than 200,000 suspected radicals. On a single night in January of 1920, federal agents arrested more than 4,000 people in 33 cities, most of them without warrants, many of them held for days without being allowed to call a lawyer or a family member. Some were beaten. This was, again, the United States government doing this to people whose main offense, in the overwhelming majority of cases, was being foreign-born and politically inconvenient. Sacco and Vanzetti were not bystanders to this atmosphere. They were exactly the kind of men it was built to catch. In the summer of 1917, after the United States passed a new conscription law, Galliani urged his followers to avoid the draft rather than resist it publicly, and a group of them, Sacco and Vanzetti among them, crossed briefly into Mexico rather than register. They came back that September, once the immediate danger of arrest for draft evasion had passed. It was not their finest hour, and the prosecution would later use it against them at trial as proof of bad character. But sit with the shape of it for a second. Two immigrant workers, already reading a newspaper the federal government considered dangerous, had already once made the calculation that when the state came looking for men like them, the safest answer was to not be found. By the spring of 1920, that calculation was about to be tested again, and this time, the stakes were going to be a great deal higher than a delayed draft card. On the 25th of February 1920, a New York printer named Andrea Salsedo was arrested in one of Palmer's raids. Salsedo was part of the same Galleanist network Sacco and Vanzetti belonged to. He had helped print anarchist pamphlets, some of them the same violent material the government was hunting for. He was held for 8 weeks inside the Bureau of Investigation's offices, on the 14th floor of a building in Lower Manhattan, without formal charges, without access to a lawyer, without his family being told where he was. On the 3rd of May 1920, his body was found on the pavement in front of that building. He had gone out a window on the 14th floor. To this day, nobody can tell you with certainty whether Andrea Salsedo jumped or was thrown. What is not disputed is that word of his death moved through the Galleanist network within hours, and that it moved through that network as exactly the kind of story an already frightened community would believe without needing much convincing. A man is taken. A man is held for weeks with no lawyer and no phone call. A man goes out a 14th floor window. If you were an Italian anarchist in Massachusetts in the first week of May 1920, and you had a house full of the same kind of literature Salsedo had been printing, you would have been afraid too. 2 days after Salsedo's death, on the evening of May 5, 1920, Nicola Sacco and Bartolomeo Vanzetti went out to retrieve a car. But to explain why that ordinary errand ended with both of them under arrest, we have to go back 3 weeks earlier, to the crime the two of them would spend the rest of their lives being asked about. And I want to be honest with you about the order these events actually happened in, because it matters. The robbery came first. Salsedo's death came second. The arrest came last, 3 weeks after the crime and 2 days after the death. And on the night it happened, Sacco and Vanzetti were not thinking about a payroll robbery at all. They were thinking about hiding anarchist literature before the raids that had just killed a friend of theirs came for them next. On the afternoon of April 15, 1920, a paymaster named Frederick Parmenter and a guard named Alessandro Baradelli walked down Pearl Street in South Braintree, Massachusetts, carrying 2 steel boxes. Inside those boxes was $15,776.51, the payroll for the workers of the Slater and Morrill Shoe Company, due at the factory within the hour. They never made it. 2 men were waiting near the fence line along Pearl Street. As Baradelli reached for his own revolver, he was shot 4 times and went down in the road. Parmenter, trying to run, was shot twice, 1 bullet catching him in the back. A dark blue Buick pulled up. The gunman climbed in alongside at least 3 other men already inside the car, and the boxes went with them. The Buick sped off down Pearl Street, past a line of workers on a lunch break, past a group of school children who would later be asked, more than once over the following year, to describe what they had seen from a moving car traveling at 15 to 18 miles an hour. Baradelli died where he fell. Parmenter died the next morning. I want to pause on those 2 names for a moment, because a case this famous has a way of turning its victims into scenery. Frederick Parmenter and Alessandro Baradelli were not symbols of anything when they left the factory office that afternoon. They were 2 employees carrying somebody else's money, because it was their job to carry it, on a street they walked every payday, in a town where nothing like this had happened before. Baradelli was himself an Italian immigrant, a detail that tends to get lost in a story that is so often told as immigrants against the state. Whatever this case eventually became, whatever it still means to historians and documentarians a century later, it began as two working men shot down over a shoe factory's payroll, and their deaths are not an asterisk in anyone's political argument. They are the reason any of the next 7 years happened at all. Two men murdered in broad daylight on a public street in front of dozens of witnesses for a sum of money that would be worth roughly $260,000 today. That is what the state of Massachusetts had to solve. And here is the detail I want you to sit with for a second, because it is going to matter for the rest of this story. Almost every eyewitness who saw that Buick saw it for a matter of seconds, from a distance, in motion. Nobody stood over that fence line taking notes. What the state eventually built its case on was memory. Memory of strangers, glimpsed for 1 or 2 seconds, recalled with increasing confidence as the months went by. It took police weeks to develop a real lead. A stolen Buick, matching descriptions of the getaway car, was found abandoned in the woods near Bridgewater. Investigators traced its trail to a garage in West Bridgewater, where the owner told them a foreign-looking man had come around asking about a different car, a Buick that had been left there for repairs. That car, it turned out, belonged to a man named Ferruccio Coacci. He happened to be an Italian anarchist facing deportation, and he happened to have worked, at different points, at both of the shoe factories that had been targeted for robbery, the successful one in April, and an earlier failed attempt the previous December. Coacci had left the country abruptly, days after the Braintree robbery. On the same day he was scheduled for deportation anyway. Investigators wanted very badly to know who else might come looking for that Buick. On the evening of May 5, 1920, someone did. A garage owner and his wife, Ruth Johnson, had agreed to quietly notify police if anyone came asking about the car, and it would be Ruth Johnson who later testified she recognized both Sacco and Vanzetti from that encounter. That night, 4 men showed up. One of them, a laborer named Mario Buda, was the actual owner of the vehicle in question. He left on foot when he was told the car's registration had lapsed and it could not legally be driven that night. 2 of the others, Nicola Sacco and Bartolomeo Vanzetti, borrowed a motorcycle and rode off toward Brockton to catch a streetcar home. They were stopped and arrested that night as suspicious characters. Both men were armed. Sacco was carrying a loaded .32 caliber pistol and 23 additional cartridges. Vanzetti was carrying a loaded revolver and several shotgun shells. Neither man was told that night that he was a suspect in a double murder. As far as either of them knew, they had been picked up for being the wrong kind of foreigner on the wrong night, in a country that had just killed a friend of theirs for exactly that offense 2 days earlier. So when police asked them about their politics, about who else they associated with, about where certain other men might be found, Sacco and Vanzetti did what frightened men who had just watched a friend go out a 14th floor window might reasonably do. They lied. They denied being anarchists. They denied knowing the men police were asking about. Vanzetti later admitted the 2 of them had spent part of that same night trying to figure out how to get rid of anarchist literature stored at a friend's house, out of fear the raids that killed Salsedo were coming for their own community next. None of that, on its own, proves a robbery. A man can be a liar about his politics and still be innocent of murder. But the district attorney who built the case against Sacco and Vanzetti was going to ask a jury to believe something more specific than that. He was going to ask them to believe that the fear on display that night, the lies, the loaded guns, the frantic effort to hide radical pamphlets, was not the behavior of two anarchists afraid of deportation and violence at the hands of their own government. He was going to call it something else. He was going to call it consciousness of guilt. Whether a jury in 1921 Massachusetts could hear the difference between those two explanations, with the Red Scare still burning and two admitted anarchists sitting at the defense table, is the whole rest of this story. Within days of the arrest, a small group of Sacco and Vanzetti's fellow radicals, led by a young printer named Aldino Felicani, organized what they called the Sacco Vanzetti Defense Committee. Nobody involved could have known, in May of 1920, that this committee would still be raising money and printing pamphlets 7 years later. Over the life of the case, it would take in something like $300,000 in small donations, mostly from immigrant workers and labor unions. It spent almost all of it on lawyers, investigators, and a relentless stream of publicity. The goal, always, was to keep the case in front of a public that would much rather have forgotten about it. That committee, and the money it raised, is the reason this case ever left Norfolk County at all. Without it, Sacco and Vanzetti are two names in a local paper, convicted and executed within a year or two, the way dozens of men in their position were in that decade, without a single foreign newspaper ever learning their names. We are going to need to talk about a courtroom in Dedham, and a judge who had already met one of these men before either was ever charged with murder. But first, hold on to that cap, that bullet, and that note a little longer. We are not finished with any of them. Before Sacco and Vanzetti ever stood trial for murder, Vanzetti stood trial alone, for something else. Remember the earlier robbery, the one that failed. On Christmas Eve of 1919, 4 months before the Braintree killings, gunmen tried to rob a payroll truck belonging to the LQ, White Shoe Company in the town of Bridgewater. The attempt fell apart almost immediately. The truck's guards fired back, the robbers fled empty-handed in a stolen car, and nobody on either side was killed. It should have been a minor, forgettable local crime, one of thousands of failed robberies in that decade that never made it past a paragraph in a local paper. Instead, because police eventually connected it to the same stolen car and the same general description of foreign-looking suspects that would surface again 4 months later in Braintree, it became the thread that first pulled Bartolomeo Vanzetti into a courtroom at all. When police went looking for suspects in that failed robbery, Vanzetti's name came up, and the same district attorney's office that would later prosecute the murder case put him on trial for it that summer, months before Sacco was charged with anything at all. The judge assigned to that trial was a Massachusetts Superior Court judge named Webster Thayer. Thayer was in his early 60s by then, a man who had recently stood in front of a room of newly naturalized citizens and delivered a speech warning them about the dangers of Bolshevism and anarchism to American institutions. He was, by most accounts of people who worked in front of him regularly, a competent judge on ordinary matters. He also, by his own public statements before either trial began, already had a settled opinion about what people like Sacco and Vanzetti were. That Bridgewater case left one more open question behind it that would echo through everything that came afterward. Vanzetti never took the stand in his own defense at that trial, and to this day, historians cannot agree on why. Vanzetti himself said, at the time, that his own lawyers had talked him out of it. That lawyer later told the governor's office it was Vanzetti's own decision, made against his advice. Decades later, an attorney who had assisted on the case offered a third version. The choice, he said, had genuinely been left to Vanzetti. But only after Vanzetti was warned that prosecutors would spend their cross-examination attacking his character over his political beliefs, rather than the facts of the robbery. Vanzetti talked it over with Sacco. He chose silence rather than hand them the opening. Whatever the real reason, the result was the same. The jury was left to weigh eyewitness testimony against an unsupported alibi, with no explanation from the one person who could have offered one, and one legal analysis of the case afterward put it about as plainly as it can be put. Left to decide between the eyewitnesses and the alibi witnesses, without Vanzetti's own account of himself, a verdict of not guilty would have been unusual. Sit with that for a second, because it is going to matter again. A silent defendant is not automatically a guilty one, but a jury asked to fill a silence with its own imagination rarely fills it kindly, and this would not be the last time in this case that a choice made for understandable reasons cost these two men more than either of them could have known at the time. The jury convicted Vanzetti of the Bridgewater robbery on the 1st of July, 1920. Thayer sentenced him that August to 12 to 15 years, the maximum the law allowed for a robbery in which nobody was hurt. Vanzetti, at sentencing, accused his own attorney of having quietly worked with the prosecution to inflame the jury's prejudice against a foreign-born radical. It was an ugly, paranoid-sounding accusation. Years later, that same attorney went to work for the prosecutor's law firm. Make of the timing what you will. The record does not resolve it either way, and neither will we. What matters for where we are going next is simpler than any of that. By the time Nicola Sacco and Bartolomeo Vanzetti were indicted for the murders of Frederick Parmenter and Alessandro Baradelli, on the 11th of September 1920, one fact already sat in the record. One of the two men had already been convicted once, by a jury, in front of Judge Webster Thayer, for a different armed robbery he may or may not have committed. And when the murder case came up for trial, Thayer did not wait to be assigned to it. He asked for it. 5 days after that indictment, on the 16th of September 1920, a horse-drawn wagon, packed with dynamite and iron window sash weights, exploded on Wall Street, directly across from the headquarters of the country's largest bank. 40 people were killed. More than 130 were injured. It remains, to this day, one of the deadliest acts of terrorism in American history before the modern era. Nobody was ever formally charged, but investigators, then and since, have pointed toward the same Gallianist network Sacco and Vanzetti belonged to, and specifically toward Mario Buda, the very man whose car had brought Sacco and Vanzetti to that garage in the first place. Buda left the country for Italy within weeks of the bombing and was never extradited. I am telling you this not because Sacco and Vanzetti had anything to do with it. There has never been credible evidence that they did, and they were already in custody. I am telling you this because it is the world the jury in Dedham was about to be selected from, a jury pool drawn from a state where, 1 year earlier, a bomb tied to the defendant's own political circle had killed 40 people on the country's most famous street, was never going to hear the word anarchist as a neutral term. The trial opened on the 31st of May, 1921, in the Norfolk County Courthouse in the town of Dedham. It would run for 6 weeks. Prosecuting was Frederick Katzman, the district attorney for Plymouth and Norfolk counties, a methodical, locally respected lawyer who had already gotten one conviction against Vanzetti and clearly intended to get a second against both men. I want to be fair to Katzman for a moment, because this channel does not build its cases around villains, and Katzman does not deserve to be flattened into one. By every account available, He was not a corrupt prosecutor, manufacturing evidence out of nothing. He was an ambitious, capable district attorney, operating inside a legal culture that had already decided, well before he ever walked into that courtroom, what men like Sacco and Vanzetti probably were. He built the strongest case the physical evidence allowed him to build, argued it within the rules the court gave him, and won. Whether those rules, and that surrounding culture, gave him an unfair advantage before the trial ever started is a different question entirely, and it is the question this video is actually asking. It is very rarely the question of one bad man doing one bad thing. It is almost always the question of an ordinary, competent professional doing his job exactly as his profession had trained him to do it, inside a system that had already tilted the floor before he took a single step. Defending Vanzetti were two brothers, Jeremiah and Thomas McInerney, local Norfolk County attorneys. Defending Sacco, at least at first, was a very different kind of lawyer. Fred Moore had made his name in California, defending members of the industrial workers of the world, and he arrived in Massachusetts with California habits that Massachusetts had not asked for. He took off his jacket in the courtroom. He sometimes took off his shoes. During one lunch recess, in the trial's first week, Thayer told reporters exactly what he thought of him. "I will show them," Thayer said, "that no long-haired anarchist from California can run this court." That comment did not come from a rumor or an affidavit collected years later. It was said to journalists during the trial, in the first week, and it was reported at the time. Sit with that for a second. Before the jury had heard a single piece of ballistics evidence, the judge who would decide every objection for the next 6 weeks had already told the press how the trial was going to go. Security around the courthouse was extraordinary for a robbery murder case. Heavy steel doors, some of them painted to look like ordinary wood, were installed at the entrances. Armed guards escorted the defendants to and from the courthouse every day. The atmosphere was not that of a routine criminal proceeding. It was the atmosphere of a siege, and everyone inside the building, judge, jury, lawyers, and defendants, knew it. Selecting the jury took most of a week and revealed just how hard it was going to be to find 12 men in that county willing to sit through a capital case. More than 500 potential jurors were summoned and questioned. Most were dismissed over their opposition to the death penalty. When the regular pool ran out, deputies were sent to find replacements at workplaces, at social clubs, at a concert hall. One man was located at his own wedding dinner and brought straight from the reception to the courthouse. He postponed his honeymoon. The 12 who were finally seated were sequestered for the entire 6 weeks, sleeping on cots in the courthouse's grand jury room, bathing in the basement of the county jail. On the 4th of July, in the middle of their sequestration, the court arranged for them to be taken to Situate for a lobster dinner. I mention that detail not because it changes anything about the evidence. I mention it because it is worth remembering what those 6 weeks actually were. 12 ordinary men spent that entire summer locked into a single building with this case, fed and housed by the same court system that was asking them to hand down a verdict before they ever retired to deliberate. There is a strange footnote to how those 12 men were found in the first place, and I think it belongs here. Deputies searching for replacement jurors, once the standard summons pool was exhausted, went looking in the places ordinary men happened to be gathered that week: workplaces, social clubs, a concert hall. One man was located at his own wedding dinner, still in his good suit, and was brought directly to the courthouse to be questioned for a capital case. He was seated, He postponed his honeymoon for a murder trial he had no connection to and had not volunteered for. I tell you that, not because it changed the verdict, but because it is a useful reminder of how much of what decided Sacco and Vanzetti's fate came down to which ordinary men happened to be standing in which room, on which afternoon, in the summer of 1921. The defense itself was not a unified operation, and it is worth being honest about that too, because the myth of this case sometimes flattens 7 years of internal argument into a single righteous team fighting a single villain. Fred Moore answered to the Sacco Vanzetti Defense Committee, the same organization Aldino Felicani had built out of nothing in the days after the arrest. And Moore spent as much of the committee's money on private investigators chasing the actual perpetrators as he spent on courtroom strategy. Some of the anarchists funding him were furious about it, viewing detective work aimed at proving a specific alternate theory of the crime as a distraction from what they saw as the real fight, a political one, about the state's right to persecute radicals at all. That tension between the lawyers who wanted to win an acquittal and the movement that wanted to win an argument never fully resolved. It would eventually cost Moore his job. By the time the case reached its final years, he had been replaced by William Thompson, a far more conservative establishment Boston attorney, who believed, correctly as it turned out, that a jury already suspicious of long-haired radicals from California was never going to be won over by one. Now, the evidence. The Commonwealth's theory rested on 3 legs, and I want to walk through each one the way the jury had to, because the strength of this case was never going to be about drama. It was going to be about arithmetic, and about whether that arithmetic actually added up the way the prosecution said it did. Leg 1. Eyewitness identification. Several witnesses told the jury they had seen Sacco or Vanzetti at or near the crime scene. The most vivid of them was a bookkeeper named Mary Splain, who worked in a building overlooking Pearl Street. Splain testified with striking, specific confidence that she had seen Sacco in the getaway car, described his hair, his hand, the grip of his weapon. Here is the detail the defense would spend years trying to make the public understand. Splain's own testimony placed her somewhere between 60 and 80 feet from a car, moving at 15 to 18 miles an hour, and by her own account, she saw the man she identified for somewhere between 1.5 and 3 seconds. She had not been able to identify Sacco at all in the days immediately after the crime, when a prosecutor first asked her to look at him. Over the following year, her recollection did not fade. It sharpened. By the time she reached the witness stand, a glimpse of 1.5 seconds through a moving car window had become detailed enough to describe a man's hand on a gun. I am not telling you Mary Splain lied. I am telling you what the distance was. I am telling you what the speed was. I am telling you what the window of time was. And I am letting you decide for yourself what a human memory is capable of manufacturing, in good faith, over the course of a year, under the weight of knowing 2 men's lives depend on the answer. She was not alone up there. A machinist named Louis Pelser told the jury Sacco was, in his exact words, the dead image of the murderer he had seen firing a gun that afternoon. Other witnesses placed Vanzetti behind the wheel of the getaway car, or near it moments before or after the shooting. In total, the Commonwealth put 59 witnesses on the stand across the 6-week trial. The defense answered with 99 of its own, alibi witnesses, character witnesses, and its own experts, walking the exact same streets and the exact same minutes, and describing something closer to 2 ordinary men nowhere near South Braintree that afternoon. 158 people, combined, stood in that courtroom and told 12 jurors what they remembered. Judge Thayer himself, writing later, would insist that the verdicts did not actually rest on the eyewitness testimony at all, that the jury had convicted on the strength of the physical evidence and the defendant's own conduct instead. Whether that is a reassurance or an admission depends entirely on how much you trust the physical evidence we just finished walking through. Because both defendants also offered an alibi, and it is worth hearing what it actually was, since this case is so often remembered as though neither man ever tried to account for his own whereabouts that day. Sacco testified that on the 15th of April 1920, he had not been anywhere near South Braintree at all. He said he had traveled into Boston that morning to have a photograph taken for a passport application, part of a plan, he said, to take his family back to Italy for a visit, and he produced documentary evidence to support the trip. Several witnesses, including officials at the Italian consulate, gave testimony that placed him in Boston that day, though the prosecution worked hard to poke holes in the exact timing. Vanzetti's alibi was simpler and, in its own way, harder to verify. He said he had spent that Thursday doing what he did most Thursdays, pushing his cart through Plymouth selling fish. A customer named Angelo Guidabone took the stand and testified he had personally bought cod from Vanzetti that same afternoon. A self-employed peddler with no time clock and no co-workers to vouch for him was always going to have a harder time proving a negative than a factory employee with a passport photographer's appointment book. That asymmetry was not evidence of anything. It was simply the shape of the two men's very different lives showing up one more time in a courtroom that was not built to account for it. Leg 2. The cap. Investigators recovered a cloth cap near where Baradelli fell, and the prosecution argued it belonged to Sacco. In court, Sacco was asked to try it on. According to courtroom sketch artists and reporters present that day, the cap sat too small and too high on his head to be a comfortable fit. Katzman pushed back hard on that impression, pointing to a torn place inside the lining that he said matched a nail Sacco was known to hang his cap on at the shoe factory where he worked. It was a small, almost intimate piece of testimony, the kind of detail that either convinces a jury completely or means nothing at all. Investigators who searched Sacco's own home found several caps belonging to him. By at least one account, none of them matched the one found in the street closely enough to settle the question on sight. That is part of why the trial narrowed down to one torn strip of lining and the nail Sacco supposedly hung it on. 6 years later, when the case reached its final review, Braintree's police chief, a man named Jeremiah Gallivan, was asked about that cap under oath, and he admitted something that had never been made clear to the original jury. He had found the cap in the street, a full 24 hours after the murders, with the crime scene having stood open the entire time to state police, local police, and by his own estimate, 2,000 or 3,000 curious onlookers. And he admitted that he was the one who had torn it open, examining the lining himself, before it was ever properly preserved as evidence. He told the committee, in words that have survived precisely because of how plainly damning they are, that watching the handling of evidence in this case had been like watching a contest to see who could tell the biggest lies. Hold that cap in your hand for a second, not as a conspiracy, just as a fact about a piece of physical evidence that a jury was asked to trust completely, torn open by the wrong person's hands, a full day after the crime, in front of thousands of witnesses who could have contaminated it in 100 ordinary ways nobody was ever able to rule out. Leg 3. The Ballistics. This is the one you have been waiting for, Because I asked you to hold on to a number at the very beginning of this video, and here is where it belongs. 4 bullets were recovered from Alessandro Baradelli's body. The Commonwealth's forensic witnesses, an army officer named Charles Van Amberg and a state police captain named William Proctor, testified that one of those 4 bullets, the fatal one, known throughout the case simply as Bullet 3, was consistent with having been fired from the pistol found on Sacco at his arrest. Cartridge casings found at the scene were also compared to test rounds fired from Sacco's weapon. Here is the arithmetic. Sacco's gun was a .32 caliber Colt automatic. There were, at the time, something like 300,000 of that exact make and model in circulation across the United States. Consistent with is not the same claim as fired by. And after the trial was already over, Captain Proctor signed a sworn affidavit walking back the strength of his own courtroom testimony. He stated, under oath, that he had never been able to say Sacco's pistol was the only weapon in existence capable of firing Bullet 3. Only one of the 4 bullets taken from Baradelli's body was ever matched to Sacco's gun at all. The other 3 were never conclusively tied to either defendant's weapon. I want to be fair to the other side of this, because the honest version of this story does not end with the ballistics evidence collapsing cleanly in the defendant's favor. It does not. In the decades after the execution, the physical evidence was re-examined more than once, with better equipment than existed in 1921, first in the 1930s, again in 1961, and again in 1983. Each of those later examinations reached the same conclusion the original prosecution reached. The barrel of Sacco's pistol matched the rifling marks on Bullet 3. At least one respected historian has raised a chain of custody problem. The bullet and casing used in some of those later tests, this historian argues, may not have been reliably continuous with the original crime scene evidence. The physical exhibits passed through a great many hands over the years. That includes, and we will get to this, a period when a Commonwealth ballistics expert simply kept the guns and bullets at his own home. That argument has never been fully settled either. So here is where the arithmetic actually leaves us, and I am not going to pretend it leaves us anywhere cleaner than this. The best evidence available, examined and re-examined across 60 years of improving forensic science, points toward Sacco's pistol having fired the bullet that killed Alessandro Baradelli. That same evidence, examined at the time it mattered most, in 1921, was presented to a jury by a witness who later admitted under oath that his trial testimony had overstated what the science could actually prove. Both of those things are true at once. A conviction can rest on evidence that turns out, decades later, to have been directionally correct and still have been an unfair, overstated, prematurely certain thing to put in front of 12 men deciding whether 2 other men would live or die. Those are not the same question, even though this case has spent a century collapsing them into one. Vanzetti's gun tells a messier, and in some ways more troubling, story. No physical evidence ever tied his revolver to a fired shot at the crime scene. All 6 recovered bullets were .32 caliber, fired from automatic pistols, not from a revolver like the one Vanzetti carried. Instead, the Commonwealth built an entirely different theory around his weapon. Alessandro Baradelli, the murdered guard, had been known to carry a .38 caliber revolver for his job. That revolver was never found on his body. Katzman argued to the jury that Vanzetti's revolver was, in fact, Baradelli's own gun, taken from his body during the robbery. Vanzetti told 2 different stories about where his revolver came from, and the differences between them did him real damage. To the police on the night of his arrest, he said he had bought it for protection and could not quite recall the details, and he described a weapon with the wrong number of chambers. On the stand, he told a fuller story, that he had bought the revolver months before the murders from a fellow anarchist named Luigi Falzini for $5. Falzini himself took the stand and confirmed it, testifying that he had originally bought the gun from a third man, Riccardo Orciani, and sold it on to Vanzetti well before the Braintree robbery ever happened. The Commonwealth countered with a receipt. Baradelli's widow testified that her husband's revolver had been dropped off for repair at a gun shop weeks before he died, and the shop's own repair ledger showed a revolver logged in for a new hammer and a new spring. It looked, on paper, like exactly the kind of detail that closes a case, except the shop's own records never recorded a serial number. The caliber written in the ledger did not match Baradelli's actual gun, and the defense produced its own gunsmiths, who examined Vanzetti's revolver and testified that no new hammer or spring had ever been installed in it. Two respected ledgers, two respectable witnesses, two irreconcilable stories about the same piece of metal, and a jury that had to pick one. One more piece of arithmetic belongs here, and it is the kind that rarely makes it into the shorter versions of this story. $15,776.51 was stolen from Frederick Parmenter and Alessandro Baradelli that afternoon. Not $1 of it was ever traced to Nicola Sacco or Bartolomeo Vanzetti. No sudden purchase, no unexplained bank deposit, no change in either man's plainly modest standard of living ever surfaced, in 6 weeks of trial or in 6 years of appeals that followed it. Sacco kept working at the same shoe factory. Vanzetti kept pushing the same fish cart. Whoever actually carried that money out of South Braintree, the two men who were executed for taking it, were never shown, by any evidence anyone ever produced, to have kept a cent of it. That is the entire physical case, laid out flat, the way the jury actually had to weigh it. A cap that did not sit right, examined by the wrong hands a day late. A bullet that later science says probably did come from Sacco's gun, presented at trial by an expert who later admitted he had claimed more certainty than the evidence supported. A revolver with 2 competing paper trails, neither one airtight. Which brings us to the part of the trial that had almost nothing to do with any of that, and that both sides understood, at the time, mattered more than all of it combined. Fred Moore made a decision, partway through the defense case, that would follow this trial into every history written about it afterward. He put both defendants on the stand, and he let them explain, in their own words, why they had lied to police on the night of their arrest. He wanted the jury to hear about Salsedo, about the raids, about 2 frightened immigrants trying to protect themselves and their friends from a government that had just killed a man for exactly the beliefs they held. It was, on its face, not an unreasonable strategy. It was also a door, and once Moore opened it, Katzman walked straight through it. Consciousness of guilt is a real legal concept, and it deserves a fair explanation before I tell you how it was used here, because the doctrine itself is not the problem. In an ordinary case, a court is allowed to consider whether a defendant's behavior after a crime, fleeing, lying to police, destroying evidence, suggests an awareness of guilt that an innocent person would not display. It is a reasonable idea. An innocent man usually has less reason to run. The trouble is that the doctrine depends entirely on there being no other honest explanation for the behavior in question, and Sacco and Vanzetti had one sitting in plain sight. two admitted anarchists, questioned by police 2 days after a friend of theirs went out a 14th floor window in federal custody, had an obvious, well-documented reason to lie about their politics and their associates that had nothing to do with a robbery at all. Katzmann's entire strategy was built around denying the jury permission to consider that second explanation, and cross-examining Sacco and Vanzetti about their political beliefs was how he did it. Over defense objection, and with Thayer's approval, Katzmann pressed both men on why two men so devoted to their adopted country would flee to Mexico rather than register for its draft in 1917. He built, across days of testimony, a portrait for the jury, not of two robbery suspects with an understandable fear of federal violence, but of two dangerous radicals who had already shown, once before, that when the United States government came looking for them, their answer was to run and hide. The word anarchist, which had walked into that courtroom simply meaning what Sacco and Vanzetti believed about how a society should be organized, walked back out of it meaning something closer to a verdict all by itself. Katzmann never had to prove that word committed murder. By the time his cross-examination was finished, he did not need to. The jury retired to deliberate on the afternoon of July 14, 1921. They returned at 7:30 that evening. Guilty, on both counts, for both men. Two immigrant workers who had already told the jury, out loud, in open court, exactly what they believed about God, the state, and private property, were now also convicted murderers. The two verdicts did not require a single moment of jury deliberation about ballistics evidence. To almost everyone watching from outside Massachusetts, entirely predictable. In New York, the verdict ran 3 sentences long, on page 3. In the Italian language press, in the anarchist and labor press, and within a few months, on the front pages of newspapers across Europe and Latin America, it ran considerably longer than that. The case that Frederick Katzmann had built, patiently, over 6 weeks, in a heavily guarded courthouse in a small Massachusetts town, was about to become one of the most contested criminal verdicts of the 20th century, and the men who had delivered it were about to spend the next 6 years insisting, through every available legal channel, that they had gotten it right. A guilty verdict is not the end of a case in a system that allows appeals. It is closer to the opening move. Over the next 6 years, the defense filed motion after motion for a new trial, and Judge Thayer, the same man who had privately told reporters what he intended to do to the defense before the trial even started, was the same man who ruled on every single one of them. Before we follow those motions through 6 years of courtrooms, it is worth pausing on what those 6 years actually cost the two men living through them, one appeal at a time, with no way of knowing which motion, if any, would ever be the one that mattered. Sacco wrote home constantly. In one letter, describing a rare, joyful visit from his wife and children, he told a friend how happy he had felt to see them so joyful and so gay and in the best of health. It is a small, ordinary sentence, but it is the kind of sentence a father writes when an ordinary visit has become the entire shape of his week. In another letter, written to a woman who had befriended the family from outside the case entirely, he reached backward instead of forward. He remembered the vineyard his own father had kept in Italy. It had been 16 years, he wrote, since he had left it. And he described in aching detail, searching as a boy for red roses among the vines, a man facing a possible death sentence, spending his allotted letter for the week on roses he had not seen since he was a teenager, is not a detail that changes a single piece of ballistics evidence. It simply tells you what waiting 7 years for an answer actually felt like, from the inside, for at least one of the two men whose fate an appeals court somewhere was, at that exact moment, still deciding how urgently to review. While the lawyers argued motions, the Sacco Vanzetti Defense Committee was fighting a second, parallel war for public opinion, and it grew more sophisticated as the years went on. Aldino Felicani's original circle of anarchist volunteers gradually brought in professionals better equipped to reach an audience outside their own movement. A labor organizer named Mary Donovan joined to help run the committee's public campaign. A Boston Globe reporter named Gardner Jackson came from a wealthy, well-connected family and had no radical politics of his own. He joined in 1927 for a specific reason. He wanted to help translate the case for readers who would never pick up an anarchist newspaper. He also worked to smooth the always uneasy relationship between the anarchists funding the defense and the growing number of ordinary liberals who found themselves troubled by what they were reading. The committee sent speakers into Italian immigrant communities up and down the East Coast, week after week, for years. They told the same story over and over, to rooms full of people who did not need it explained to them. Those audiences understood, better than any editorial writer, exactly what it felt like to be presumed guilty of something the moment you opened your mouth in accented English. None of that changed a single ballistics report either. But it is the reason a robbery trial in a small Massachusetts county was still front-page news in Paris and Buenos Aires 6 years after the jury went home. And it is worth remembering that the appeals process and the public campaign were never really two separate stories. They were the same fight, running on two different clocks. One motion, filed in the fall of 1923, centered entirely on the ballistics evidence. A defense expert named Albert Hamilton asked the court to let him demonstrate something, physically, in front of the judge. The internal parts of a .32 caliber Colt automatic he wanted to show were interchangeable between one gun and another. If he could prove that, it would undercut the state's confidence that the fatal bullet could only have come from Sacco's specific weapon. Hamilton brought 2 brand-new Colt automatics into the courtroom alongside Sacco's own pistol, disassembled all 3 in front of everyone, and began sorting the parts into piles to make his point. Thayer stopped him before he could finish and ordered Sacco's pistol reassembled using only its own original components. That same round of motions carried one more piece of evidence worth hearing, because it had nothing to do with ballistics at all, and everything to do with the 12 men who actually decided this case. The defense produced a sworn affidavit from a friend of one of the trial jurors, stating that before the trial had even finished, the juror had told him, in reference to Sacco and Vanzetti, damn them, they ought to hang them anyway. If true, it meant at least one of the 12 people sworn to weigh this case with an open mind had already reached a verdict before the evidence was in a case where the state was asking for a death sentence. Thayer denied the motion built around that affidavit along with all the others. We have no way, a century later, of asking that juror what he actually meant, or whether the friend's account was accurate at all. We only have the sworn statement, sitting in the record, unresolved, the same way almost everything else in this case sits unresolved. Then, in February of 1924, something stranger happened. At Thayer's request, the prosecution's own ballistics witness went back to re-examine Sacco's pistol and discovered that its barrel was not the same barrel that had been in the gun during the original trial. It was brand new, still coated in the greasy preservative manufacturers use to protect an unused gun barrel from rust. somewhere between the first trial and this re-examination, the barrel inside the single most important piece of physical evidence in a capital murder case had been switched. Thayer held 3 weeks of private hearings, trying to determine who had done it. Hamilton swore he had only ever touched the gun under the judge's own supervision. The defense's lead attorney by that point, a Boston lawyer named William Thompson, told the court flatly that no one connected to the defense would have dared switch a barrel in a case like this one, given what it would cost them if they were caught. Thayer made no finding. Nobody was ever charged. The rusty original barrel was ordered returned to the gun, and the case moved on, with one of its central physical exhibits now carrying a question mark that was never publicly resolved. There is one more piece of that same gun story, and I want to tell you now, even though the world did not find out about it until decades later. After those hearings, the Commonwealth's ballistics expert took Sacco's pistol, Vanzetti's revolver, the bullets, and the shell casings, and brought them home. Not to a police evidence room, to his own house, where they apparently stayed for years. It would take a Boston newspaper investigation in 1960, more than 3 decades after the executions, to bring that fact into public view at all. I am not telling you this to suggest the evidence was faked. I am telling you because it is simply true, and because a piece of evidence that spent years sitting in one man's private home is not a piece of evidence any court today would call properly secured, whatever it does or does not prove about who fired the fatal shot. Thayer denied every motion connected to the ballistics and barrel questions on the 1st of October 1924. The defense appealed to the Massachusetts Supreme Judicial Court, the state's highest court, which heard arguments in January of 1926 and issued a unanimous ruling that May upholding Thayer's decisions. It is worth being precise about what that ruling actually said, because Thayer himself would later describe it, in public, as the High Court approving the guilty verdicts. That is not what it did. Under Massachusetts law at the time, the Supreme Judicial Court's job was not to decide whether Sacco and Vanzetti were guilty, or even whether they had received a fair trial in any broad sense. Its job was narrower than that. It could only decide whether Thayer had abused his discretion on specific, individual legal rulings. The court found that he had not. It never actually reviewed the trial as a whole, and it said so. While that appeal was still working its way through the courts, something happened inside the Dedham jail that would end up mattering more than any ballistics report. In November of 1925, a prisoner named Celestino Madeiros, an ex-convict awaiting the outcome of his own murder conviction in an unrelated case, passed a note to Nicola Sacco. In it, in his own uneven handwriting, Madeiros confessed to taking part in the South Braintree robbery himself and stated plainly that Sacco and Vanzetti had not been there. Read that again, slowly. A man with nothing obvious to gain, already convicted of a separate killing, with an appeal of his own still pending, wrote down that he had committed the crime 2 other men were sitting on death row for. The defense investigated. Madeiros would not name his accomplices directly, but the details he did offer, combined with information investigators gathered independently, pointed toward a Rhode Island crew known as the Morelli Gang. These were men with a documented history of robbing shoe factory payrolls, and their methods matched the Braintree crime closely. Their leader, a man named Joe Morelli, reportedly bore a real resemblance to Sacco. William Thompson took the Madeiros story to Judge Thayer in the spring of 1926, asking for a new trial based on this newly discovered evidence. I want to be fair to the difficulty of what Thayer was actually being asked to evaluate here, because the honest version of this story includes real, serious problems with Madeiros's account, not just the parts that helped the defense. Madeiros described the getaway happening in the middle of the afternoon, when multiple witnesses had placed it hours earlier, closer to midday. He described the stolen payroll being carried in a black bag, when trial testimony had established it was carried in a metal box. He could not recall basic details about the neighborhood where the robbery happened, or even say clearly how many people had been killed. When the case eventually reached a formal review, the reviewing committee would describe his account bluntly, saying his ignorance of what had actually happened was extraordinary for a man claiming to have been there. Both of those things are true at the same time, and I am not going to pretend otherwise. Madeiros's confession had real, specific, documented holes in it, and it also lined up, independently, with an entire alternate gang, an alternate motive, and an alternate physical resemblance that the original jury never got to weigh against anything. A flawed confession is not the same thing as a false one. It is also not the same thing as a proven one. Thayer heard arguments on the Madeiros motion in September of 1926, and 5 weeks later, on the 23rd of October, he denied it. In his written ruling, he dismissed Madeiros's story as unreliable, untrustworthy, and untrue, and he went further, describing the entire defense theory as resting on what he called a new type of disease, a belief in something that had no actual existence. 3 days after that ruling, in an editorial titled, "We Submit," the Boston Herald did something almost no other major American newspaper had done up to that point. It reversed its own earlier position and called openly for a new trial. The editorial writer would win a Pulitzer Prize for it. Almost no other paper followed. The defense appealed Thayer's denial of the Madeiros motion to the Supreme Judicial Court one more time, arguing the case in late January of 1927. And while that final appeal was pending, a Harvard law professor entered the story and changed its shape entirely. Felix Frankfurter, who would go on to sit on the United States Supreme Court, published a long article in the Atlantic Monthly in March of 1927, laying out, in careful legal language, everything he believed was wrong with how the case had been handled. He wrote that Thayer's 25,000-word opinion, denying the Madeiros motion, was, in his words, a farrago of misquotations, misrepresentations, suppressions, and mutilations. He argued that every reasonable probability pointed away from Sacco and Vanzetti and toward the Morelli gang. It was a devastating, meticulously sourced piece of writing from one of the most respected legal minds in the country, and it moved public opinion in a way that 6 years of anarchist newspaper coverage never had. It also moved the Commonwealth of Massachusetts to do something worth pausing on. Weeks after Frankfurter's article ran, the Massachusetts Attorney General, a man named Arthur Reading, authorized wiretaps on the telephone line at Frankfurter's own home in the town of Duxbury. A sitting Harvard law professor, arguing a legal position in a national magazine under his own name, had his phone tapped by the government whose handling of the case he was criticizing. I am not editorializing when I tell you that. I am reading it off the record. Think for a moment about what that decision actually says about how the Commonwealth of Massachusetts had come to view this case by the spring of 1927. It was no longer treating Sacco and Vanzetti's defenders as lawyers making an argument. It was treating them as a security problem, the same category of threat it had once applied to Andrea Salsedo, to the men who bombed Wall Street, to the entire Galleonist network the state had spent 7 years afraid of. Felix Frankfurter had never robbed a payroll, never touched a gun, never advocated a single act of violence in his life. He had simply read a trial transcript and written down what he found in it, and the state's response was to listen to his phone calls. On the 5th of April, 1927, the Supreme Judicial Court affirmed Thayer's denial of the Madeiros motion one final time. The court's own language is worth hearing exactly as it was written because it tells you something true about the limits of the appeals system these two men were trapped inside. It is not imperative, the court wrote, that a new trial be granted, even though evidence is newly discovered and, if presented to a jury, would justify a different verdict. Sit with that for a second. The state's highest court did not say Madeiros was lying. It said that even if a jury might have reached a different verdict after hearing his story, that possibility alone was not enough to require them to hear it. 4 days later, on the 9th of April 1927, Sacco and Vanzetti stood before Judge Thayer to be sentenced. We will get to what they said, but first there is a governor, a committee of 3 men from Harvard and MIT, and a world that was no longer willing to look away. By the spring of 1927, this was not a Massachusetts story anymore. Public demonstrations demanding a new trial had already taken place in Boston in 1925, and again in 1926. Letters and petitions were arriving at the American Embassy in Paris by the sack. Committees had formed in dozens of countries. Albert Einstein signed an appeal. George Bernard Shaw and H.G. Wells added their names. Even Benito Mussolini, who had personally survived 2 anarchist assassination attempts and had no natural sympathy for men like Sacco and Vanzetti, quietly pressed the American government for clemency, apparently convinced their trial had been unjust. Facing that kind of pressure, and facing a final round of clemency appeals, Governor Alvin Fuller did something that, on paper, looked like real independence. On the 1st of June, 1927, he appointed a 3-man advisory committee to review the entire case from the outside, separate from the courts entirely. He chose Abbot Lawrence Lowell, the president of Harvard University, Samuel Stratton, the president of MIT, and Robert Grant, a retired probate judge. On paper, it was hard to imagine a more credentialed panel. In practice, not one of the 3 had significant experience trying criminal cases. At least one defense attorney close to the case worried openly, at the time, about what that meant. Men who had spent their careers running universities and probate courts, he feared, were not necessarily the right people to unwind 6 years of contested forensic testimony in a matter of weeks. Each of the 3 men brought his own history into that room. Grant had spent decades on the probate bench. He had also written a shelf of popular novels on the side, and some of them leaned on the same casual language about immigrants and foreigners that this entire case turned on. It was a detail his own biographer would later admit. It made him an odd choice to judge whether ethnic prejudice had infected a courtroom. Stratton kept the lowest profile of the 3, saying little during the public hearings, and leaving almost no independent trace on the final report. Lowell was, by far, the most consequential appointment, a man supremely confident in his own analytical mind, who reportedly believed he could succeed where career criminal lawyers on both sides had spent 6 years failing, simply by reading the transcript with fresh eyes. Defense attorneys close to the case considered resigning in protest when the committee's makeup was announced. Felix Frankfurter and a sitting federal appeals judge both urged them to stay, arguing Lowell was, in their words, not entirely hopeless. Time would tell whether that assessment was too generous. Around the same time the committee was doing its work, the ballistics question got its most rigorous examination yet. A ballistics expert named Calvin Goddard, who had personally helped invent a device called the comparison microscope, a tool that let an examiner view two bullets side by side under matched magnification for the first time, was brought in to re-examine the physical evidence. The defense refused to take part. The prosecution agreed to it. Using his new instrument, Goddard compared bullet 3 and a shell casing recovered at Braintree against fresh test rounds fired from Sacco's own pistol. He reached two conclusions. The rifling marks on bullet 3 matched Sacco's barrel. The firing pin scratches on the shell casing from the scene matched marks left by that same weapon. It was, at the time, the most technically credible ballistics conclusion the case had yet produced, built on genuinely new forensic science rather than the competing eyeball testimony that had convinced the original trial jury. It would not be the last word, but it was the first result that came from an instrument built specifically to answer this exact kind of question, rather than from a witness simply telling a jury what he believed he saw. The Lowell Committee's hearings ran through most of July, and for the first time, under oath, in front of an official body with real institutional standing, witnesses were finally asked directly about Judge Thayer's own conduct, on and off the bench. What came out was worse than the single lunch recess comment that had already been reported back in 1921. Multiple witnesses swore, in affidavits collected specifically for this review, that they had personally heard Thayer refer to Sacco and Vanzetti as Bolsheviki, and had heard him say he intended to get them good and proper, long before either man had been convicted of anything. One Massachusetts attorney swore that Thayer had confronted him years earlier at Dartmouth College and asked, gloatingly, whether he had seen what Thayer had done with those anarchistic bastards, adding that he guessed that would hold them for a while. A Boston Globe reporter named Frank Sibley had covered the trial gavel to gavel for 6 straight weeks. Immediately after the verdict, he wrote a formal letter of protest to the state's own attorney general, specifically about Thayer's visible bias in the courtroom. That letter sat in a file for 6 years, until the Lowell Committee finally asked to see it. The New York World, reviewing the same conduct from outside Massachusetts entirely, had already gone further than most, describing Thayer in print as an agitated little man looking for publicity and utterly impervious to the ethical standards one has the right to expect of a man presiding in a capital case. Newspapers publish harsh lines about public officials constantly, and most of them are forgotten within the week. That one was still being quoted back at the Lowell Committee 6 years later, because nothing that happened in between had done anything to disprove it. The Lowell Committee heard all of it, and then it concluded that the trial had been fair. The committee did not pretend Thayer's conduct outside the courtroom was acceptable. In its own report, borrowing Judge Grant's own words, it stated plainly that Thayer ought not to have talked about the case off the bench, and that doing so was a grave breach of judicial decorum. But it found no evidence that any of it had reached the jury or affected the verdict, and it concluded, after reading the trial transcript itself, rather than watching it live, that Thayer had, in its words, tried to be scrupulously fair. It reported that the jurors themselves, when interviewed, were nearly unanimous in praising his conduct. I am not going to tell you the Lowell Committee was corrupt. I do not think the evidence supports that, and this channel does not deal in that kind of certainty when the record itself does not offer it. What I will tell you is what one member of the legal team defending Sacco and Vanzetti said afterward, which is that the committee's report abruptly stilled the burgeoning doubts among the leaders of opinion in New England, at exactly the moment those doubts might have mattered most. 3 respected men, working in good faith, reviewing a transcript instead of living through 6 weeks in that courtroom, looked at a mountain of contested, contradictory evidence, and came down on the side of the system that had produced it. Both of those readings of what happened in July of 1927, that the process finally worked, and that the process simply protected itself, live inside the same 3 weeks of hearings. The record does not force you to choose. It never has. Not everyone was willing to be that generous about it. The British political theorist Harold Laski, writing privately to the American Supreme Court Justice Oliver Wendell Holmes shortly after the report came out, put it more bluntly than any historian since has managed to improve on. Lowell's loyalty to his class, Laski wrote, had transcended his ideas of logic and justice. That is one man's private opinion, not a finding of fact, and I am giving it to you as exactly that. But it captures something true about how a great many of Sacco and Vanzetti's supporters experienced that summer. 3 of the most credentialed men in New England had been handed a genuine chance to say the system had failed, and instead they had spent 3 weeks proving, to their own satisfaction, that it had not. Governor Fuller announced, on the 3rd of August, 1927, that he would not intervene. The executions, twice postponed already, were rescheduled for the week of the 22nd. Let's go back 4 months, though, to the 9th of April, 1927, because before any of that happened, Sacco and Vanzetti stood in front of Judge Thayer, one final time, to be formally sentenced to death, and both of them were given the floor to speak first. I am going to read you what they actually said, as close to word for word as the surviving transcript allows, because I do not think anything I could summarize would carry the weight of hearing it the way the room heard it that day. Sacco went first, and he went briefly. English was not a language he had ever felt fully at home in, and he said so. I am no orator, he told the court. It is not very familiar with me, the English language. Then he said this: I never knew, never heard, even read in history, anything so cruel as this court. He told Judge Thayer that the case, as he understood it, would be decided along class lines, between what he called the oppressed class and the rich class. And near the end, his composure broke, not for himself, but for the man standing beside him. My comrade, he said, the kind man to all the children. You sentenced him 2 times, and you know he is innocent. Vanzetti spoke for far longer, and what he said has outlived nearly everything else about this case. What I say is that I am innocent, he began, not only of the Braintree crime, but also of the Bridgewater crime. He told the court he had struggled his whole life, since he had first been old enough to reason, to eliminate crime from the earth, not to commit it. And then he said something that has been quoted for 100 years since, because it names, more precisely than any historian ever has, exactly what this case was actually about. I would not wish to a dog, he said, or to a snake, to the most low and misfortunate creature of the earth. I would not wish to any of them what I have had to suffer for things that I am not guilty of. But my conviction is that I have suffered for things that I am guilty of. I am suffering because I am a radical, and indeed I am a radical. I have suffered because I am an Italian, and indeed I am an Italian. He closed with this: if you could execute me 2 times, and if I could be reborn 2 other times, I would live again to do what I have done already. "I have finished. Thank you." Judge Thayer's response to both statements was short. "The court," he said, "has absolutely nothing to do with that question," meaning the question of guilt itself, which the jury alone had decided. He sentenced each man to suffer the punishment of death by the passage of a current of electricity through your body, and set the execution for the week, beginning that July. It would be postponed twice more before it actually happened. In the 4 months between that sentencing and the night it was finally carried out, both men kept writing. Sacco had been writing to his wife and children for years by then. Ordinary letters, asking about his son's schoolwork, describing the ache of missing his daughter's early childhood, entirely from inside a cell. Vanzetti, who had no wife or children of his own, wrote instead to the wider circle of people who had spent 7 years fighting for him. And in his final weeks, his letters took on the tone of a man addressing history directly rather than any one person. "This is a war of plutocracy against liberty," he wrote to the Defense Committee in early August. "We die for anarchy," he wrote, spelling it his own way. Long life anarchy. In a letter written to Sacco's young son Dante, days before the end, he wrote that Dante's father had sacrificed everything dear and sacred to the human heart and soul, for liberty and justice for all. And he said, one more time, what he had been saying from the start. They were not criminals. They had been convicted on a frame-up and denied a new trial. Sacco's daughter Ines, the child his wife had been carrying on the night of his arrest, had been born into this case rather than into an ordinary childhood. By the time her father sat in Charlestown State Prison writing his final letters, she was a small girl who had spent her entire remembered life visiting him behind bars, and who was about to spend the rest of it without him. On the 3rd of May, 1927, Vanzetti had submitted a formal clemency appeal to Governor Fuller, asking for mercy. Sacco refused to sign a similar appeal himself. He would not ask a system he believed had already decided his guilt in advance to now perform the theater of considering his mercy. A week later, on the 10th of May, a package bomb addressed to Governor Fuller was intercepted at a Boston post office before it reached him. Whoever sent it was never identified. The case that had begun with 2 frightened men and a stolen car was now, on both sides, generating the kind of violence it had spent 7 years arguing about. In the final full week before the execution, the president of the American Federation of Labor wrote directly to Governor Fuller. He pointed not to any single piece of evidence, but to the sheer length of the ordeal itself. He cited what he called the long period of time intervening between the commission of the crime and the final decision of the court. He cited the mental and physical anguish which Sacco and Vanzetti must have undergone during the past 7 years. It was, in its own way, one of the more damning appeals filed on their behalf, because it did not ask whether they were guilty at all. It simply asked whether 7 years of that particular kind of waiting was a punishment any court had actually meant to hand down. The industrial workers of the world called for a 3-day nationwide walkout that same week. The response was uneven, almost everywhere except one place. In the coal fields of Walsenburg, Colorado, 1,132 out of 1,167 miners walked off the job, a strike that would keep running long after the reason for it had already been decided in Boston. On Sunday, the 21st of August, more than 20,000 people gathered on Boston Common. 2 days earlier, a bomb had gone off at the home of one of the original Dedham jurors. Whoever was setting off bombs in support of Sacco and Vanzetti that week was not making their case any easier to hear. At 8:40 in the evening, on the 22nd of August, 1927, the warden of Charlestown State Prison informed all three condemned men, Sacco, Vanzetti, and Celestino Madeiros, that the night had come. Vanzetti paced his cell and was heard to say, "We must bow to the inevitable." Sacco spent part of his final hours writing a letter to his father back in Italy and asked the warden to see that it was mailed. Both men declined a chaplain's offer of religious consolation. Neither had ever practiced a faith, and neither pretended to find one now. Celestino Madeiros went to the chair first, just after midnight. Sacco followed at 11 minutes past 12. Witnesses said he walked in with a steady step and a pale face, and that as he was seated, he called out, in Italian, "Long live anarchy." In broken English, he added, "Farewell, my wife and child, and all my friends." His last words, spoken as the switch was thrown, were two, "Farewell, mother." Vanzetti was brought in, several minutes later. He shook hands with the guards escorting him before he sat down, and his final statement to the room was this: "I wish to tell you that I am innocent, and never committed any crime, but sometimes some sin. I thank you for everything you have done for me. I am innocent of all the crime that is attributed to me, not only of this, but also of the other one. I am an innocent man. I wish to forgive some people for what they are now doing to me." He was pronounced dead 6 minutes later. It was not yet 1 in the morning. 3 men had died in that room within the space of roughly 20 minutes. The reaction outside that prison was immediate, and in places, violent. Within a day, demonstrations turned destructive in Geneva, London, Paris, Amsterdam, and Tokyo. Strikes closed factories across South America. Riots in Germany left several people dead. In Buenos Aires, a furious crowd attacked the American embassy. In Boston itself, more than 10,000 mourners passed through a funeral home in the North End, over 2 days, to view the 2 men's bodies, laid out in open caskets beneath a wreath that read, in Italian, "Awaiting the hour of vengeance." On the 28th of August, a funeral procession moved through the city for 2 hours. Estimates of the crowd that turned out to watch it ran past 200,000 people. Police blocked the route from passing directly in front of the State House. There were clashes anyway. One Boston newspaper called it one of the most tremendous funerals of modern times. After the service, the bodies were cremated, and the ashes were carried back across the Atlantic to Italy to be buried, at last, in the towns both men had left as teenagers, chasing a version of America that had, in the end, strapped them into a chair and killed them. 2 months after the execution, the English writer H.G. Wells tried to explain to his own readers why a robbery trial in a small American county had produced riots on 5 continents. And his answer is worth hearing because it is the clearest statement anyone made at the time of what this case had actually become. He compared it to the Dreyfus affair, a scandal that had convulsed France 3 decades earlier, when a Jewish military officer named Alfred Dreyfus was falsely convicted of treason on evidence that later proved to be forged, largely because his background made him a convenient target for the Army's own institutional prejudice. Wells called it a trial by which the soul of a people is tested and displayed. And he told his American readers something plainly uncomfortable. Most of the world protesting in the streets that week had never much cared, one way or the other, whether these 2 specific men had personally committed a specific robbery. "The guilt or innocence of these 2 Italians," he wrote, "is not the issue that has excited the opinion of the world. What had excited the world was the same question Dreyfus had asked France 30 years earlier: whether a country's legal system could be trusted to treat an unpopular outsider fairly, or whether it would simply confirm, every time, whatever that outsider's enemies already believed about him. The violence did not end with the funeral. An Italian anarchist living in Argentina, a supporter of the two men named Severino di Giovanni, bombed the American embassy in Buenos Aires within hours of the sentencing months earlier. In the years that followed the execution itself, he kept going. He bombed a tobacco shop that had floated the idea of selling cigarettes under the Sacco and Vanzetti name. He bombed the Buenos Aires offices of two American banks. He even tried, unsuccessfully, to bomb the train of an American president-elect passing through Argentina. The executioner himself, a man named Robert Elliott who had thrown the switch for both Sacco and Vanzetti that night, found his own front porch destroyed by a bomb the following spring. None of that violence brought either man back, and none of it changed a single legal fact about the case. It is simply part of the record of what this execution set in motion, on top of everything it had already cost. Judge Webster Thayer paid a price of his own that had nothing to do with any court's judgment. Threats against him were constant enough, in the years surrounding the trial, that he traveled with police protection. In September of 1932, 5 years after the executions, his own home was bombed, injuring his wife and his housekeeper. He spent the remainder of his life living permanently inside a Boston club, under guard around the clock, rather than in his own house. He died in April of 1933, not quite 6 years after he sentenced 2 men to death, for a case even his own state's highest court would later admit it had never fully reviewed. There is one quieter consequence of this case that almost never makes it into the retellings, and I think it belongs here because it is the one piece of this story that actually changed something. The same appeals court that had told Sacco and Vanzetti it lacked the power to review their full trial record, even after new evidence emerged, became, within a decade, the center of a serious legal reform movement inside Massachusetts. Legal scholars and the state's own Judicial Council pointed directly at this case as proof that the old rule was broken. In 1939, the Massachusetts legislature finally changed the law. From that point forward, the state's highest court would be required, in every capital case, to review the entire trial record and to overturn a verdict for any reason justice might require, not merely for a narrow, technical abuse of discretion. 2 men had to die before that rule existed. Every capital defendant in Massachusetts after them got a wider door than Sacco and Vanzetti ever had. The case did not stay confined to courtrooms and legislatures either. In 1928, Sacco and Vanzetti's prison letters were collected and published for the first time. The journalist Walter Lippmann, a man not given to sentimental overstatement, read them and reached a striking conclusion. If Sacco and Vanzetti were professional bandits, he wrote, then historians and biographers who attempt to deduce character from personal documents might as well shut up shop. By every test he knew of for judging character, the letters read like the letters of innocent men. Not everyone was willing to go that far. The novelist Upton Sinclair spent that same year researching a novel about the case, eventually titled simply Boston. While he was doing it, Sacco's own former lawyer, Fred Moore, told him something privately. Moore believed both men were in fact guilty, he said, and he had personally arranged false alibi testimony to defend them anyway. Sinclair called it an ethical problem and, in the end, chose not to put Moore's private confession in his book at all, publishing a novel sympathetic to both men, without ever telling his readers what their own attorney had told him. I mention that not to settle the guilt question. By now you understand, this case refuses to let anyone settle it. I mention it because it says something honest about how badly the world wanted this to be a simple story, even when the people closest to it were telling each other, privately, that it was not. The writer John Dos Passos joined the defense committee himself and wrote his own account of the case. His conclusion split the two men apart. It was barely possible, he thought, that Sacco had committed the robbery as an act of what he called class war. But Vanzetti was, in his own words, clearly innocent. His theory was simple. No one planning an armed robbery in his right mind would have brought a man as recognizable and unpredictable as Vanzetti along for it. Nearly a decade after the executions, in 1936, a group of 28 Harvard alumni, marking the university's 300th anniversary, published a public statement attacking the retired Abbot Lawrence Lowell directly for his role on the governor's advisory committee. The case had outlived the two men it killed by that point. It had outlived the judge who sentenced them and the governor who refused to stop it. It was becoming something closer to an open wound in the country's memory of itself, one that a formal apology, when it finally came, would only partly close. That apology came on the 23rd of August, 1977. 50 years to the day. Michael Dukakis had been governor of Massachusetts for less than a year when he issued a formal proclamation naming that date Nicola Sacco and Bartolomeo Vanzetti Memorial Day. He released it in both English and Italian. He called on the people of Massachusetts to reflect upon these tragic events and to draw from their historic lessons the resolve to prevent the forces of intolerance, fear, and hatred from ever again uniting to overcome the rationality, wisdom, and fairness to which our legal system aspires. Listen closely to what that proclamation did not say. It did not say Sacco and Vanzetti were innocent. Dukakis was careful, deliberately careful, to base his statement entirely on the fairness of the process, not on the guilt or innocence of the two men who went through it. Earlier attempts, in 1937, 1947, and again in 1957, to present a Sacco and Vanzetti memorial sculpture to the city of Boston, had all been formally refused. It had taken 40 years just to get a governor willing to say, in public, that the trial itself had failed these two men. It took another sentence Dukakis chose not to write, to remind everyone that admitting a process was broken and admitting a specific verdict was wrong are two entirely different confessions, and the state of Massachusetts, even 50 years later, was only willing to make the first one. So where does that leave the actual question this case has been asking for a century? Were Nicola Sacco and Bartolomeo Vanzetti guilty of murder? I told you at the start of this video that I was not going to pretend the record settles that question cleanly, and I meant it. Here is the honest shape of where modern historians actually land, and it is messier than either side of this argument usually admits. The physical evidence, re-examined with better technology across 60 years, most consistently supports the conclusion that Nicola Sacco's pistol fired the bullet that killed Alessandro Baradelli. That finding has survived multiple independent re-examinations, even as serious questions remain about how carefully that same physical evidence was handled and stored across the decades in between. Vanzetti's connection to the actual shooting has never had anything close to that level of physical support. No evidence ever tied his revolver to a fired shot at the scene, and the case against him rested almost entirely on contested eyewitness identification and a disputed pistol receipt. And underneath both of those individual questions sits the one this entire case actually turned on from the very first week of trial, which has nothing to do with ballistics at all. Would either man have been convicted, on this evidence, in front of this jury, without a judge who had already told reporters what he intended to do to them, in a state gripped by a fear of foreigners and radicals that treated the word anarchist as a verdict all by itself? Nearly every serious historian who has studied this case, including some who believe Sacco's gun probably did fire the fatal shot, agrees on that much. The process that convicted these two men was not built to find out what actually happened on Pearl Street. It was built to convict two men who had already been sorted, well before the trial started, into the category of people this country was afraid of. I want to give the other side of that argument its full due, though, because it is a real scholarly position, and not simply a fringe one. Historians including Paul Avrich, one of the most respected chroniclers of the American anarchist movement, have pushed back against the simplest version of the wrongful conviction story. Both men, they point out, genuinely were members of a militant organization. Its adherents had, in fact, carried out armed robberies to fund their activities. Its newspaper had, in fact, printed instructions for building the kind of bomb that killed 40 people on Wall Street. Some historians go further. They argue that the federal and state governments prosecuted Sacco and Vanzetti for this specific robbery, partly as a convenient, legally clean way to remove two members of a genuinely dangerous bombing network from the streets. Whether or not these two particular men had personally pulled the trigger on this particular afternoon was, in that reading, almost beside the point. That argument does not make the trial fair. It does not resolve the ballistics question, the cap question, or the Madeiros question in the state's favor, but it complicates the comfortable image of two harmless immigrant workers persecuted purely for holding unpopular opinions, and a channel that promises you the trial record, rather than a fable, owes you that complication, even this late in the story. This case never really left American law after that either. Generations of law students have studied it since, not primarily as a murder mystery, but as a case study in what happens when the machinery meant to protect a fair process gets captured by the exact fear it was supposed to guard against. The 1939 reform to the state's appeals law is one direct legacy. The far more diffuse legacy is the case's name itself, which has functioned for a century now as a kind of shorthand, invoked whenever a legal proceeding looks less like a search for the truth of one specific event and more like a verdict on who the defendant already was walking in the door. That is not a comfortable inheritance for a state to carry. Massachusetts carried it for 50 years before it said anything about it publicly at all, and even then, it chose its words with a precision that should tell you something about how carefully the state still felt it needed to tread, half a century on. Walk into the John Adams Courthouse in Boston today. It is the building that now houses the state's own highest appeals court, the direct descendant of the very court that twice told Sacco and Vanzetti it lacked the power to fully review their case. Inside, you will find a permanent exhibit the Commonwealth itself put up, titled simply Justice on Trial. Its own stated purpose is to aid the public's understanding of, in the state's own words, the importance of striving always to be a government of laws and not of men. Massachusetts did not tear this case down and bury it once the 50th anniversary passed. It built a room for it inside the courthouse and left the door open. A cap, a bullet, a note. I ask you to hold on to them at the very beginning, So let's put all three down, one at a time, and see what we are actually left holding. The cap sat too small on Nicola Sacco's head in a courtroom in 1921, and 6 years later, the man who found it admitted he had torn it open himself, a full day after the murders, with thousands of onlookers already trampling through the crime scene before he ever got there. Nobody has ever proven that cap belonged to Sacco. Nobody has ever proven that it didn't. It sat for decades in an evidence room, a small piece of cloth doing an enormous amount of work it was never actually equipped to do. The bullet, the one investigators called Bullet 3, has been tested and retested for the better part of a century, and the most recent science says, with real confidence, that it likely came from Sacco's gun, out of the 300,000 identical guns that could have fired something just like it. That same bullet was first presented to a jury by an expert witness who later admitted, under oath, that he had claimed more certainty on the stand than the evidence actually supported. Being right, decades later, does not erase having overstated it at the time it mattered most. And the note, 5 uneven handwritten lines from a convicted killer with nothing obvious to gain, confessing to a crime that would send him to the same chair regardless, sat inside a legal system that read it, weighed it, and decided, twice, that it changed nothing. Not because the system proved Madeiros was lying, because the system decided that even if he might have been telling the truth, that possibility alone was not enough to open the door back up. Here is the word I asked you to notice, without telling you I was asking: anarchist. Nicola Sacco and Bartolomeo Vanzetti used that word about themselves before anyone ever accused them of anything. It meant, to them, a belief that ordinary people deserve to organize their own lives without a landlord, a boss, or a government standing over them with a gun. By the time Frederick Katzmann finished his cross-examination in the summer of 1921, that same word had quietly become something else in that courtroom. Not a belief anymore. A verdict, arrived at before the jury ever left the room, that a jacketless lawyer from California and a judge with a grudge had both, in their own ways, already reached before the evidence was fully in. Anyone who tells you this case is settled, cleanly, in either direction, guilty men who deserved exactly what they got, or 2 innocent immigrants murdered by the state for their politics, is telling you something the actual record does not support. Both of those stories are more comfortable than the one the evidence actually leaves behind. The truth, as best as a century of historians, ballistics experts, and one deliberately careful governor have been able to reconstruct it, is smaller and harder to sit with than either version. A trial happened that was not fair, in a country that was not calm, in front of a judge who had already decided what these 2 men were before he ever heard a single witness. And somewhere inside that unfair process, one true verdict may have landed by accident, wearing the same coat as 100 wrong ones. Let's do the arithmetic one final time, because this channel trusts arithmetic more than it trusts anyone's argument, including its own. From the night Nicola Sacco and Bartolomeo Vanzetti were arrested as suspicious characters on a streetcar to Brockton, to the night they were pronounced dead in a wooden chair in Charlestown, 2,666 days passed. Not 7 years as a round, comfortable figure. 2,666 specific mornings, each one arriving without an answer, for 2 men who had spent the entire stretch insisting, in 2 languages, in open court and in private letters, that the state had the wrong men, or at the very least, the wrong process. Nicola Sacco and Bartolomeo Vanzetti spent 7 years, 2,666 days, waiting to find out which one they were going to get. So, in the end, did everyone else. The cap is still in a box somewhere in Massachusetts. Nobody is coming to test it again. Now you carry the record.